Good evening, ladies and gentlemen, and welcome to the Monday night edition of the People Show with Mark Wallace, your host and facilitator, here with you every Monday night from 7 o'clock until 9. Come on in, and we would love to have you be a part of this great program that we have lined up here for you tonight. It is going to be a great program. I've got a couple of guests coming up. We're going to be having a roundtable tonight. We're going to be talking with two of the Illinois Appellate Court justices, two of the most brilliant ones. That is Appellate Court Justice Cynthia Cobbs and Appellate Court Justice Carl Walker. And they're going to be joining me in just a few minutes, a little bit later on in the program. We're going to be doing a roundtable talking about the Appellate Court. You know, you have your state courts where you file your lawsuits, or you might be a party to a lawsuit. And then the outcome of that case goes to a jury or a judge. They make a decision on that case. And if you don't agree with the ruling, your next level is at the appellate court, where you can file for an appeal of that lower court's decisions. And we're going to be talking about that whole process coming up a little bit later on in the program. And then also we're going to be continuing what I am calling our continued education about the Biden-Harris administration and their accomplishments for the country and their accomplishments for the Black community. And what those landmark policies that the president and Kamala Harris, the vice president, have been able to get passed, and what those policies coming out of those bills are doing and will do for Black communities for decades to come, all could come to a halt if we don't do the right thing on November the 5th and re-elect Joe Biden and Kamala Harris as president for 2025, because the other side has a plan called Project 2025 that the Heritage Foundation has put together. It is a 900-page manifesto of rolling the clock back. If you haven't seen it, go look it up and read it. It has gripping erosion of our democratic process, our democratic norms, of what they plan to do in the first 180 days of the election. So if you want to have an extremist group of people controlling the country and rolling back the clock of any progress that we've made, that's what we are in for if the most extreme people become in control of the government. That means we have to re-elect Joe Biden and Kamala Harris. We have to take control of the House and the Senate, because we have to make sure that our democratic process, albeit as imperfect as it is, we have to maintain what we have so that we have the opportunity to become a more perfect union. You hear that all the time. Well, it's in our face that if we don't do this very thing, this is what we are going to be subject to in making sure that our democratic process is protected. Our democratic norms are kept in place so that we can make them better, not make them worse. When you hear people like the other side talking about we need to make America great again, the question becomes, when was it great? At what period of time are they saying that it was great? When Black people didn't have the right to vote? When lynching was a part of the norm, it was okay? What period of time are they saying that America was great, because they use that slogan, let's make America great again, and great again for whom. So listen to those buzzwords, because that is essentially what they are talking about. So we're going to be talking about that later on in the program. So I'd ask for you to make sure that you reach out to your colleagues or your social media outlet, and have them to join us for the Monday night edition of the People Show on intellectualradio.com, who facilitates our show, and you're able to get us on iHeartRadio as well as on Apple Podcasts. If you do not get to hear all of the program and you want to go back, or you hear the program and you may have forgotten some things and you want to listen to it again, you can go on iHeartRadio and on Apple Podcasts, and you'll be able to get it. Or you can go to my YouTube channel at Mark Wallace, The People's Show, and you'll be able to get it there. So you got to make sure you put in Mark Wallace, The People's Show, or The People's Show with Mark Wallace, so that you get the most recent programming. All right. And then again, tomorrow night, we're going to be on at 9 o'clock with the Cook County Circuit Court Judge, Leonard Murray, who will be on taking your legal questions tomorrow night at 9 o'clock. And and again, those of you who would like to join us, the men, calling on men, we're going to be doing a 200-man press conference, 200-man press conference on July 19th in front of the Markham Courthouse at 9 o'clock that Friday, July the 19th, where we're going to be doing a press conference. And what we're doing is we're calling on all of our local, state, and federal officials that we are demanding demanding that they take action to deal with what we are finding out, that Black women, being 16% of the population in Chicago, but yet they are 30% victims of all crimes rated. That means they are 1 in every 3 crimes committed in Chicago, Black women are victims of. That has to be dealt with. That sends a message that to assault Black women is a very low risk crime, and it must be dealt with. It's continued. We saw on the 4th of July, 2 women, a 42-year-old and a 22-year-old woman in a home was murdered, and a 5, 7, and 8-year-old child shot. One of them died. This has to be dealt with, and this is a state of emergency. In my opinion, this is a state of emergency, and we have to deal with it. So I'm calling on 200 Black men. So you can join me for that Zoom meeting tomorrow night, and I'll put the Zoom meeting in the link tonight, and you can get it. I'll put it in the chat, and that you can get it if you will join us for the planning meeting. This is for Black men. Black men, we have got to lead. We've got to show Black women of our city, of our county, and of our state that we actually care about what is going on, and we're going to do something about it. And I'm calling on Black male politicians. I'm calling on Black men who are in public office to stand up. Black men in public office must stand up. Dorothy Tucker did this special more than now 7 months ago. And in that special and after that special, not a single Black male public official said a word, not one. This story came out January the 6th or 7th, the week before the Dr. King holiday, 2 days before the mayor's interfaith Dr. King breakfast, which I attended, and the mayor didn't say a single word about it. And neither did any other Black male public official. And so I'm calling on all of the Black men, all of those men who are doing the great work of violence intervention and mediators, and those who have been doing the work for a long time and advocating on behalf of Black women who are missing and Black women who have been murdered, and the unresolved crimes against Black women, calling on all of you to become a part of this collective stance, this collective call to action of our local, state, and federal officials to come up with the resources to put as an urgent priority as COVID. This is an epidemic. This is an epidemic that we are experiencing, and nobody is really talking about it, especially in the places and high places where they should be talking about it, bringing serious attention to this and bringing some resolve that it is not okay. And there must be serious accountability for everybody, all of us, to stand up for our women, for our girls. How do we expect for our boys to have respect for our women and for our girls if we men, Black men, are not standing up for our sisters and our daughters? Because yes, all of our women are our sisters and our daughters. Even if they're not our blood, we are responsible for them. That is the attitude that we must take, that we're responsible for them. So we're gonna certainly make sure that on July the 19th, asking for all Black men to join us for that press conference. And again, I'm going to put it in the chat. I'm going to put the link in the chat so that you can share it with some Black men that you know, to have them to become a part of that press conference. We have to deal with this carnage that is happening, that we are our Black women and our young girls are falling victim to. I mean, get this, 16% of the population of Chicago. Black women are 16% of the population of Chicago, yet they represent 1/3 victims of all crimes reported in the city of Chicago. that sends an indication that whoever attacks a black woman or a girl has maybe the idea that it is a very low risk crime because there's not much accountability to it. Now, we saw an example of that when the Cook County State's attorney was attacked 3 weeks ago. Now, the person who did that attack is being held accountable, but we are using that as a backdrop to call attention to the broader problem of black women being attacked here in Chicago and around the Chicagoland area, and there's not much done about it. There's very little being said about it, and we have to call to action. If black men don't stand up for black women, the game is over. If we don't show concern for the women who are our mothers, our sisters, our wives, our daughters, our nieces, our granddaughters, if black men don't stand up, who is going to stand up for our women? If black men stand silent, saying nothing, doing nothing, then the perpetrators think that it's okay. Shame on us if we don't stand up to make sure that we do what is the right thing. All right, so we're going to be talking about that a little bit later on. I'm going to put the link up in the chat, and you can share that with other black men. Tomorrow night, we're having a meeting at 6 o'clock. 6 o'clock Zoom meeting. I'll put the Zoom link up in the chat, and you can share it with other black men and ask them to please join us for that meeting as we are organizing this 200 black men press conference for July the 9th, right outside the Markham Courthouse, 9 o'clock, Friday, July the 19th, which is the day that William Waltz, who is the 34-year-old white male that attacked the Cook County State's attorney, threw a large drink in her face, and then tried to run her over with his vehicle sometime in the morning as she was doing her walk. Yeah, we've got to take a serious stand for that. All right, coming up, who is going to be joining us? See, one of the appellate court justices is in the waiting room. We're waiting for appellate court justice Carl Walker to join us. And don't forget, coming up just a little bit later on in the program, I'm going to be going through item by item, line by line, so that you all can know what the policies that are coming out of the Biden-Harris administration, how those policies directly are impacting black communities, black education, black institutions have received $16.5 billion from the Biden-Harris administration. And I want to make sure that we get this right. We have to get this right on November the 5th. We have to make sure that we do not allow for the extremists of the extreme to take control of our government and erode and end our democratic norms as we have. They're not perfect. We need to make them better, but we certainly don't need to allow for the clock to roll back. So stay tuned for that. That's going to be coming up a little bit later on in the program. All right. Still waiting for our guests to come in. We have Appellate Court Justice Cynthia Cobbs is in the green room. And so we're going to be bringing her on in just a few minutes. Also, tomorrow night at 9 o'clock, we do our weekly legal hour with Cook County Circuit Court Judge Leonard Murray, who takes your legal questions from 9 o'clock until 10. So tomorrow night, we're going to be discussing liability for uninsured motorists. We got a lot of questions about those this week, so that is going to be something that we're going to be talking about tomorrow night. But tonight we're going to talk about the appellate court and its process, and we're going to be talking with two of the appellate court justices in just a few minutes, and you'll get a chance to hear from both of them. I'm going to hopefully. Our other guest is going to be logging in, and I'll just reach out to them and let them know we're still waiting for them to come on in. Let's see here. Waiting for you to log in. All right. I'm going to bring on my first guest, Appellate Court Justice Cynthia Cobbs. How you doing?
I'm well. How are you, Mark? It's always
great
fantastic.
To see you. I'm fantastic. It's always great to see you. Thank you very much for being here.
My pleasure.
Good. Now, I know that we're in the middle of a campaign, right? We're in the middle of a campaign, but your campaign is over, right?
My campaign should be over. I was successful in the primary in defeating my sole opponent. Mm-hmm. And I don't have an opponent on the November ballot. So I'm coasting at this point. I am the nominee. All I need is one vote.
Okay. All right. I'm sure you'll get much more than that. But, speaking of the primaries, I've been talking about primaries because primary elections are very important. They're very important. Now, here in Illinois, generally, our primary elections is really more like our general election. They're very important. Right. But even for down ballots for, our national and state and national election, it's very important for people to participate. People don't participate at the level that they ought to participate in.
Right.
Except for Republicans are using primary elections so that they can put more of their extreme people in these other places like school board elections and some of these local and state offices to further what their agenda is. And I think that we have to learn and understand the importance of really being in actively involved in every aspect of our democratic process.
I think you raise a really great point. Throughout the judicial campaign for me, which just ended in March for me, you would frequently hear voters say, "Well, I'm just going to wait until November." And we would have to explain to them, well, if you wait until November, you've waited too long. Because to the extent that you have an opponent, and I did have an opponent in the March primary, if I had lost the March primary, I wouldn't be on the November ballot. My opponent would be on the November ballot. So it is critical that all of those individuals who are registered to vote, and I am encouraging everyone, even if you missed the primary, please get out and register to vote. I encourage everybody who is registered to vote, don't ignore the primary. That's really where much of the game is. That's where the opponents are facing off. So I was not fortunate enough to be unopposed in the March primary. I had someone who was running vigorously against me. I am a 9-year veteran on the Illinois Appellate Court. That notwithstanding, I had a trial court judge running to take my seat. And so had the voters not come out for me in March and in the primary, it is quite conceivable that my inexperienced trial court opponent, who's never served a day on the appellate court, whose bar ratings were far less than stellar, would be occupying my seat in November. And as you know, Mark, in Cook County, we are largely Democratic. We are blue. It is odd or rare to find a Republican opponent in Cook County running for a judgeship. That doesn't say there aren't any, but I had a Democratic woman running against me in the primary. And had the voters not come out for me in March, we would have someone who is frankly less qualified than am I on that ballot in November, seeking to serve the public on the appellate court. Critical seat, as you know.
Yeah, and the other side of that, a testament to that, by even having an opponent and you prevailed over that opponent, is a real testament to who you are and what your credentials are and what your qualifications are and what your record is. So I think it's more of a testament of that, but I think it's important that people understand the consequences of elections and the consequences of not participating in elections. And that's one of, in particular, in the Black community, that where we are positioned here in the Midwest. I say to people all the time, the way that we're positioned and the numbers that we have in Chicago and Cook County is not typical for around the country. So we really have to understand the position that we're in and the potential that we have if we use what we have available to us, because there are a lot of other places in this country where Black people don't have that large of a voice to be able to make a political statement.
No, absolutely. And particularly in Cook County. And Mark, just talking about the judiciary, we have one of the largest judicial systems in the country. Cook County enjoys 24 appellate court justices and more than 400 circuit court judges, associate and full circuit. So we're a pretty big deal in terms of judgeships and our size. And so to the extent that we can make an impact, or to the extent that we do make an impact on the lives of everyday people, it is imperative that individuals who might someday be confronted or be in the justice system, civil or criminal, it is imperative that you exercise your right to vote, exercise your voice in voting and in understanding how the judicial branch works and how it works for you, or how it can hurt you if you don't know what you're doing or don't know who you're voting for.
Right. Absolutely. It matters. It absolutely matters. I'm not sure what happened to our other panelists.
My colleague is missing.
Yeah, your colleague is missing. I know that he's traveling, so maybe something happened. But we were certainly looking forward to having this panel, because I think that it's critical for the public to see, because they just hear about the appeals court, or they hear about an appellate court justice, but they don't really understand, or certainly don't really get to see or to get to have an understanding of what that process is like, where you have a panel of justices all looking at different cases that have been argued before a court, and there has been decisions, and one side or the other don't agree with that decision or didn't like the decision, and appeal that to the next court, which is the appellate court. But you have a panel of justices who are looking at the same case and the same arguments and the decisions, and you have to render your decisions on that. And would certainly like to have people to understand what that process is like. So if you can bring us into that process, and what the appellate court is, and then I'll ask some other questions that the average person would like to ask. In particular, we'll talk a little bit about the Supreme Court, but the reason why these questions came up is because a lot of people are asking questions now, which I think is a good thing, about how is it that you have 9 justices looking at one case, and you have these varying differences in opinion. If they're all looking at these one cases and using the Constitution and the law, but they have varying opinions about the conclusion. So the appellate court is a similar way, a similar body with fewer justices reviewing those cases. So bring us into that. Help us understand it.
So we'll just bring it back to Illinois, and we'll look at the state court system, because I am sitting as a Illinois appellate court justice in the state. So the appellate court is a reviewing court. And for most individuals, it is the court of last resort. And I say the court of last resort because you have the right to appeal to the appellate court. You don't have to file a petition. All you have to do is timely file your notice of appeal. That's very different from the Illinois Supreme Court and even for the U.S. Supreme Court. The Supreme Court is more of a may I appeal. It's a petition for leave to appeal. But to have your case reviewed in the Illinois Appellate Court, all you really need to do is timely file your notice of appeal following the trial court decision. So you have 30 days from the time that the trial court has rendered its last decision in a case to file your appeal in the Illinois Appellate Court. And you will have your case decided by a panel of 3 justices on the appellate court to determine whether the decision made in the trial court by that single sitting trial court was correct, whether there were errors made such that that case should be reversed, if there were no errors made such the case should be affirmed, or if there were issues that remain unsettled such that the case should be sent back to the trial court for decision. In Illinois, our appellate court, me as an appellate justice, and your guest to be, Justice Carl Walker, hear both criminal and civil appeals. We hear appeals relating to landlord-tenant disputes, debtor-creditor disputes, marriage and dissolution disputes, juvenile delinquency. Every type of case that comes through the trial court is subject to appeal to the Illinois Appellate Court. As long as you file your notice of appeal within the requisite 30 days after all proceedings have been completed in the trial court, we have jurisdiction to hear your appeal, to hear your argument, and to make a determination as to whether the trial judge made errors in your case such that it should be reversed and perhaps remanded, or whether the trial judge was spot on and the case should be affirmed. And when we finish with it, if you still don't like the result, if you think we did a mess or we made some mess, you have the right to petition for leave to appeal to the Illinois Supreme Court. And when I say petition, that is the mother may I. They don't have to hear it. If you timely file your appeal in the appellate court, we have to hear it. If you timely file your petition for leave to appeal in the Supreme Court, they don't have to hear it. They hear the fewer number of cases that are on appeal. That is why you hear more often than not individuals referring to the Illinois Appellate Court seemingly as the court of last resort, because most cases, most appeals will end there because the Supreme Court does not have to take your appeal. The appellate court, once you timely file the appeal, if jurisdiction is proper, we must hear the appeal and decide it.
What you pointed out something that's very interesting, that you hear or that you review cases, criminal, civil, all across the board. When most people in the state case or the state courts hear the same type of cases, right? You have a criminal attorney, they're not hearing civil cases, they're really presiding over criminal cases. But here at the appellate court, you're looking at the whole, bowl of soup. So you have a panel of justices that will review the same case. Now, does the 3 individual justices on the panel, you look at and review the case and you review the decisions made on those cases to see if those decisions were made correctly or incorrectly, or to such that it impacted the decision that should have gone a different way. The three of you look at that. Now, after you review it, do you discuss this between the three of you, what your review is, before you make a final vote?
There are 3 appellate court justices on every case, and we are randomly assigned a case. So in every case, there is one justice who is assigned the authoring justice, the justice who will take the lead in the case, the justice who will author or who will draft the opinion or the decision in the case, looking at whatever the issues are raised on appeal by the appellant. The losing party in the trial court is the appellant. That individual is the individual or entity that will file the brief and will tell us in that brief why they believe there were mistakes or errors made by the trial court judge. Trial court, you're sitting, one judge is hearing the evidence and making a decision. If you lose, you become the appellant if you decide to appeal to the appellate court. You then must tell us, 3 justices, why you believe the trial court's judgment or ruling was wrong. What was in error in that ruling? If you fail to raise an issue in the appellate court, we don't reach it. We don't decide, oh, the trial judge just made a mess of things. You, as the appellant, as the plaintiff or the defendant in the trial court, must say to the appellate court, these are the errors, these are the mistakes that the trial court made. And because the trial court made these mistakes, I would be entitled, but for those mistakes, I would be entitled to win, to prevail. And so, appellate court justices, I would ask the 3 of you, look at the issues that I have raised in my appeal. If you didn't raise them, you've waived them, you forfeited them. We're not going to look for them for you. You have to tell us why you think the trial court erred or made mistakes. We will look at those and determine whether error was made such that the case should be reversed, if it was reversible error, or we will look at it to determine, yes, there were errors, but the errors were harmless. It doesn't matter that they made this error. It was so inconsequential that you wouldn't have won anyway. It's harmless error. Or there was reversible error. These errors were so bad, so significant that we are reversing this, and we can either reverse it outright and give a decision, or we can reverse and send it back to the trial judge and have them do a do-over of sorts, or do certain parts of it over to make certain that we have the correct ruling in the case.
So, and once you've done that, the 3 of you looked at it, do the 3 of you conference after you've done your review of what your opinions are of the appeal? Sure.
It goes this way, and there are 6 divisions in the 1st District Appellate Court. So 1st District Appellate Court is really just Cook County because we're that big. There are 5 districts in which other appellate court justices sit. So throughout the state, there are about 52 appellate court justices. The majority of the justices sit in Cook County because we're the largest jurisdiction. So there are 24 justices who sit in Cook County in the 1st Judicial District. There are 3 who participate on every case. So we do it various ways. As an appellate court justice in my division, I will typically, if I'm the authoring justice, the justice who's assigned to take the lead, and that's random. I don't get to choose. It's random by computer. I will get a case. I will be assigned as the authoring justice. That means I take the lead. That means I do the preliminary research. I do the preliminary writing. I make the preliminary decision about how I think the appeal or the issues on appeal should be decided. I then have the role to share my findings and my proposed disposition with 2 other appellate court justices. That's the 3 on the panel. But the authoring justice, who is randomly assigned, takes the lead in developing a draft, a bench memorandum, which is typically the way that I proceed and colleagues in my division proceed. We will get a case assigned randomly. The issues will be in the briefs. The parties are required to tell us why the trial court made mistakes, and where did the trial court make mistake, and support your argument. Tell us what law supports your position. Those are in your briefs, your pleadings. The authoring justice looks at those in the first instance and then makes a proposal to the other 2 justices in the form of a bench memo, in my case, to say these are the issues that the appellant has raised in his or her brief. These are the issues that relate to that. This is how I believe the law should be decided and whether this appellant should prevail or not. So that's generally how a case is decided. And then we may or may not hear oral argument in that case. It's up to the authoring justice, although the other 2 justices who are serving on that same case, or what we call the panel, may suggest oral argument if the authoring justice has not decided to set it for orals.
So the other 2, outside of the authoring justice, you give them your review and your opinion of what was presented.
Right.
But they have to vote on that, right? They have to say, yes, I agree, or no, I don't agree, or I think that there are some, there's some parts of it that I agree with. How does that process work?
So if we all 3 agree, and a bench memo helps tremendously, because the bench memo looks at the briefs, which is really the writing from both sides, the person who's appealing and the person who won the appellee. Mm-hmm. So the authoring justice, the justice who's taking the lead on the case, will look at the briefs, will look at the record, will be assisted by his or her law clerks in looking at the entire case and drafting what is, in my case, a bench memo. I share that with my colleagues and I say to them, this is how I believe the issues in this appeal should be resolved. And at the end of the day, and at the conclusion of the review, I think the case should either be affirmed, it should be or reversed, or it should be reversed and remanded, or reversed and remanded with instructions. So I think I lost track of your question in my own kind of like diatribe.
Yeah, the question was that you have three panels, and for the
Right.
average person, they're wondering, okay, you got 3 people who are looking at the same case, all right, the same arguments, and they're wondering, how is it that you have 3 people who are looking at it and everybody doesn't come up with the same opinion?
Because sometimes we interpret the law differently. Sometimes we even will weigh evidence differently. So you have 3 individuals serving on a particular case, but we all 3 may not agree on how the law that applies in a case should be construed. So if we're looking at a statute, for instance, and there is language in a statute that says something shall, some of us may interpret the word shall to mean absolutely mandatory. Others of us may interpret the word shall as meaning not always. It may mean sometimes. So you have 3 legal minds who are reading the law, reading the briefs, reading the arguments and applying the law, but thinking about it in a way that is not always consistent. So you have reasonable minds that may differ. That is the long and short of it. And that is really the value of having 3 individuals in the Supreme Court, Illinois, 7 individuals hearing the case, because you have the opportunity to have the best possible outcome when you have 3 on the Appellate Court and on the Supreme Court, 7 legal minds really reviewing an issue on appeal, really ferreting the law, really trying to understand and construing the law and applying it to a set of facts. And so while we all have pretty similar legal training to do the work that we do, we still sometimes have different constructs, different ideas about what certain terms mean, or even the outcome of certain cases. Now, you certainly don't, I am not a judge who is outcome oriented. I follow the law as best I can. So I am really looking at the law and construing what the law means and how it's been applied in precedent in cases that have gone before me to make some determination as to how the law should be applied to the set of facts that is in the case before me. And believe it or not, we say to individuals all the time, no two cases are ever alike. There's always one single factor that will make it some way different. That will cause you to really think differently about how the law should be applied or the outcome in that case. Every case is different.
I always say it's cases are like a spool of thread. In every spool, even though it may look the same, but there is one thread that is very different from spool to spool, and it could alter the outcome of that particular case. But speaking of terminology, you use the term shall, and most people would look at that term, that word shall, as a mandate. Now, I have certainly have been involved with some advocacy work where we have been arguing about that term, shall, and that it is an absolute mandate. And of course, others didn't see it that way. How is it that language in the law, as you say, you look at it based on the law, how is it that two people look at the same law and that they have different or some emphasis on how that law is applied?
And I think it just depends on perhaps your judicial philosophy. So when you're looking at language, say in a statute, which is where you're generally going to find the word shall, or you're going to find the word may, we have something that we call statutory construction. And statutory construction, there are lots of rules that apply in statutory construction. You can even go back if the law is unclear, and you can look at the debates. What did the legislators mean when they said this? What were they talking about in the debates? And it is easy sometimes, based on similar statutory language, to have a difference of opinion as to whether the word shall is mandatory or permissive. It happens more often than not. But when you find similar language in the legislature or in statute that uses shall in the same way, and if it's been construed by hopefully a higher court like the Supreme Court to be mandatory, then it's easier. But when it's being construed for the first time in the Illinois Appellate Court, and as you know, we are often the court of last resort, and sometimes we are the first to construe. When it's being construed, there are a lot of things that you may look at to determine whether the use of the word shall is mandatory or permissive. And it does depend on where it falls in the text, what other text is included in a particular provision, if there are similar provisions, if there is prior law and legislative debates from the legislature as to why the language that's in that piece of legislation or that statute is as it states. So there are lots of things that you can look at. And sometimes language in a statute or in a rule just is not clear and lends itself to that kind of debate. And when there is significant debate in the Illinois Appellate Court, when several of our divisions or districts even disagree on the meaning of a statute, that's when we need the help of the Illinois Supreme Court, when there's been that much discord among the appellate court. Because we consider that even though we're 5 districts in the appellate court, we're one appellate court. And so when you have the 5 districts, and 5 districts are kind of at odds with what certain words mean in a particular piece of legislation, you really need the Supreme Court to arbitrate that and to make the decision as to what some language means.
So the Illinois, or well, in our case, the Illinois Supreme Court is the umpire who is not making the law, but clarifying what the law is intended to be.
Both. Because there are some cases, Mark, that go directly to the Illinois Supreme Court. So if there is a case, for instance, that in the trial court, the trial judge determined that a piece of legislation was unconstitutional, that's going to go directly to the Illinois Supreme Court. We no longer have the death penalty, but if there were a death penalty case, it would go directly to the Illinois Supreme Court. So the Illinois Supreme Court may review directly some cases pursuant to Supreme Court rule or statute. But as a general rule, the Appellate Court is the court of last resort for most civil and criminal cases.
Speaking of the Supreme Court.
Speaking of them.
We just had a consequential decision that was rendered by the United States Supreme Court on whether or not a president has, some people call it absolute immunity, some people call it some immunity, but it's been largely interpreted as that the Supreme Court, you have 9 justices, 6 voted one way and 3 voted the other way. And there were some staunch dissents, language that I've never heard, very strong language. In that decision, I want to be very careful here because I want to make sure we don't cross lines. That decision, notwithstanding any particular person, but giving that office, that decision, giving that office, whoever occupies that office, almost the unfettered ability to call whatever act that they do an official act, that most people would be considered to be committing a crime. But in this case, based on this ruling, it says to whoever the person occupying that office, we're going to relax the rules for you a bit more to kind of have a free hand to do anything. What's your thoughts on how practical that ruling was?
Well, I don't want to get too close to how practical.
Right. Okay.
For obvious reasons.
Yes.
For very obvious reasons. We have a very different system here in Illinois. As you know, the United States Supreme Court sits largely by appointment. The president makes a nomination, and then that nomination is confirmed. And so you have a little different makeup of the U.S. Supreme Court than you would have of the court system here in Illinois, where all of your judges, all of your justices on the intermediate and the highest reviewing court, the Supreme Court, are all elected by the people. And so it almost would appear as though the U.S. Supreme Court, the makeup of the U.S. Supreme Court really depends on who's in power at the time. Not so necessarily here, and certainly not so necessarily here in Cook County. So it's a little different, a little odd, I would say, the ruling, but without speaking in specifics about that particular ruling, it gives most of us some pause as to how that is going to play out. You look for certain areas, you look for every area in the law to be clear and to be a clear mandate to the lower courts So when you have the U.S. Supreme Court, and in our case, when you have the Illinois Supreme Court speaking on any issue, that really is a directive to the lower courts as to how to manage issues or controversies that come before us. And so I'm not certain, and I think I might have lost you, Mark.
No, I'm
Oh,
here.
there you are.
Yeah. Uh-huh.
For a moment, I thought, oh, I'm talking to
Yeah.
myself. And so you wonder how the rule of law that's been pronounced now, most recently by the United States Supreme Court, is going to play out in the lower courts. Should there be a case of controversy that impacts or that raises questions about the exercise of authority from the president. You seek to always be clear in your ruling. You seek always to give direction to the lower courts about what is permissible and what is not permissible, because the lower courts, we necessarily are bound by the rulings of our higher court. Our appellate court here in Illinois, we're bound by whatever the rulings are of the Illinois Supreme Court, whether we agree with them or not. They have the final say in state law and on cases and controversies that come before them. So you have to wonder what direction will be taken by the federal district and federal courts of appeals following this most recent ruling by the U.S. Supreme Court in this particular case. I'm very curious to see how it will play out.
I think we all are sitting on the edge to see how this plays out in other cases as well, and certainly how it plays out in an election, because I think that it's going to be very interesting. I've had a lot of very interesting conversation. Looks like one of our other guests are here. All right, so we're going to bring him in. This is our other appellate justice, Illinois Appellate Court Justice Carl Walker, who has joined us from somewhere else in the country, and but he has finally made it in. I'll say to the audience again, these are two people who I have an enormous admiration for and respect for who they are and what they do. So I'm very privileged to have them both here with us. Carl, thanks for joining us, and we're glad to have you.
You're welcome, Mark. Very good to be on with you. I always look forward to those opportunities. I apologize for getting on so late. I also have to recognize my dear friend, Jessica Cobbs, who I see, and she's the best. So I'm already giving the audience some great information that I've missed. But I'll jump in where I can.
All right. Okay. We'll see where we can fit you in, because she does such a phenomenal job of doing that. But I think for the audience view perspective is that one of the reasons we talked about this sometime during the election, of having this kind of a roundtable, of having a couple of the justices on who. And many people say, okay, these people, they listen to the same case. How is it that they don't come up with the same decision? And so she covered that a lot. But it'd be good to hear it from another side, from the same court. So why don't you give us a little bit of your side of how that process worked, and how has that impacted you as a justice?
Okay. Well, the first thing is that with those situations, and Justice Cobb knows this, the facts are not always identical. And very often those cases that we believe are the same facts, same case, are driven by the facts that might be slightly different from one case to another. And that's why sometimes the justices or a trial court may come out differently, where we think, oh, well, that was the exact same case. But everything is fact intensive, whether it's a criminal case, a civil case, probate case, medical malpractice, no matter what it is, it's fact intensive. And that's sometimes what controls our decisions. Not just the law. Of course, we do consider the law, and the law is a primary thing that we consider, but we also have to look at the facts and have to apply those facts to the law.
Well, let's say you're looking at the same case, not really comparing two different cases, but you're looking at the same case, one set of facts, the same set of facts being reviewed by two different people, three different people in this case, but right now we have two of them here. And you may see there's some varying differences of opinion about the same facts and the same ruling applied.
Yeah, and you're absolutely right about that. That's because of the interpretation of the law. So we're applying the law to the facts. And Justice Cobbs and I don't sit on any panels together, but if we were on a panel together and we were not agreeing on how that case should be decided, it could be because I have one interpretation of the law and Justice Cobbs has another. Not that either one of us is necessarily wrong. It's just that we're interpreting it differently. So that's another way that we could come out differently, not just based on the facts, because you just said the facts are exactly the same because we're talking about the exact same case, but the difference may be that we're interpreting the law differently.
Okay, so now, as I said to her earlier, most people don't see appellate court justices, right? But they have a view of that, okay, they're appellate court justices. They're sitting up in this palatial courtroom, and they have their, large back leather chairs, and they're sitting there and listening to arguments, oral arguments, and making a decision. And then you go back into a room and you discuss it, debate it, argue over it, and you come out with a decision. Unfortunately, television has skewered people's idea of how the court actually works. But I want them to have the real experience as to, or certainly a view of how that worked. Do you all see a case and you have such varying differences of opinion in that case? Are there times where you have real strong debate before you come to a final determination on it?
Absolutely. I think with almost every case, we have some back and forth. It may not be that real strong debate that you're talking about. We do have that sometimes. But almost every case, there may be something that one justice may say, well, I'm willing to sign off on this, but you need to change this or change that, or I don't want us to say this that way. And if Justice Cobbs and I were on a panel together and she said to me, well, Justice Walker, I don't want you to say it this way. I'd rather you say it that way. If I'm going to get her vote to say it that way, I'll say it the way she wants me to say it. Because it may not matter to me how it's said, that I just originally wrote it that way, but she's now giving me a better way to say it. And I would accept that better way to say it.
Yeah, there is a modicum of collegiality among the justices on a case. So you don't get to, there are 24 appellate court justices in the first district or in Cook County. I never get to serve with all 24 of them, but I certainly get to serve with 5 or 6 of them. And there is this give and take. It isn't always tension. It isn't always, bombastic. It usually, in my case, my panels it's always been collegial. We're respectful of each other's interpretation of the law. I can say to a justice who's serving on a case with me, I will sign off on this if you will modify the language to say this, that, or the other, to soften it. And I may say that because I may have taken a position in another case. And if you write it a certain way in your case and I'm on it, it may send a signal that I've changed positions from the case I just authored. And so there is a fair amount of give and take in cases that we are the authoring justices on. So I agree with Justice Walker. There is a lot of back and forth, not necessarily combative. Because you get to work with pretty much the same people over and over and over again in the first district. Mm-hmm. And so you pretty much know what their judicial philosophy is. You know what cases they've authored, what positions they've taken. And to the extent you can accommodate their position in a disposition, you do that if it will not compromise your position or your judicial philosophy.
Well, I think there was another court that could really learn from the example that you all have just articulated here. But um, it's really good to hear that you basically from your colleagues and from the other justices that you have such respect for each other that you sort of look to each other for guidance, or maybe not necessarily guidance, maybe that's the wrong term, but you certainly respect the other person's view of it, trying to make sure that you come to the best possible outcome.
Oh, were you looking for an audible? Well, yes. we not only want the best possible outcome, we want the right outcome.
Yes.
We want the right outcome based on the
Right.
facts in the case and the law as it exists at that time. And it's so important on the appellate court or any reviewing court that you are able to have the kind of dialogue that will yield the best possible result. Because remember, Mark, the decisions that we make are really the roadmaps for the trial court judges to follow. They have no discretion to ignore what we said in a judicial opinion. So in the first judicial district, Cook County, when a case is before the circuit court judges, they are bound by what the first district appellate court judges have said. They don't have discretion to say, oh, the justices on the appellate court said this, so what? Oh, no.
Mm-hmm.
No. So we are setting a course. We put the roadmap out there for the trial court and for litigants, for attorneys who are at the bar practicing, to know what to do, how to plead, what will be a successful argument, what is not a successful argument, what you really do need to present to support your issue or your case. And so, we work pretty collegially together.
Now,
on that really quickly, what you saw when Justice Cobbs and I didn't respond is because, for one thing, and you'll find this to be true of 90% of the justices on the appellate court, we listen and we're going to let you finish saying what you have to say before we start answering. And you didn't ask a question. You simply made a statement, and we don't see a need necessarily to always respond to a statement. Had you asked a question, we would have both responded.
Yeah, exactly.
Noted. So really, trial, it's kind of a check and balances, right? So the trial court judges certainly have to make sure that they are listening to a case and they're making rulings on that case to come out with the right outcome. Otherwise, they'll have a lot of reversals, and I certainly would assure that does not look good for the record of a trial court judge to have several opinions reversed from the appellate court on cases that they have they've heard. Are there times where you get cases that have been appealed to you that you look at them and you just wonder, how did they get this wrong?
Well, let me just say, though, in sort of for the trial court judges, it's tough sometimes. Sometimes they have to make a decision immediately. Mm-hmm. We generally have time to make our decisions. We do get motions in, and sometimes we get emergency motions, and we do make decisions the same day, the same hour that we get those motions in. Could be a situation where, say, two people in divorce court, and one person says something to the other one, and the judge says to, wife, you shouldn't have said that. You're going into custody. Send her to 26th Street. Well, if that case comes before us, we may feel that wasn't a reason to necessarily send her to 26th Street, and we may release her immediately if that were to happen. Maybe not. It just depends on the facts of every case. But my point is that we get time to make our decisions for the most part. They don't. And also, sometimes they're dealing with cases of first impression. That means that there really is no sound body of law on that particular issue. So if it then comes before the appellate court, we reverse the trial court. I would say that that's not a bad thing. That's not a mark on the trial court. They did the best that they could with the information that they had as one judge. We fortunately get to have two other people to discuss the case with and make a decision that's generally, for the most part, is going to be a better decision than one person would make. And that whole thing about, the two heads better than one, three heads are definitely better than one. And we generally have three brains working on the cases rather than the one brain that the trial court has. So I just want to say to sort of the listening audience, just because a trial court judge is reversed, I don't consider that to be a terrible mark on the trial court judge, and that they should say that judge should be removed. That's a terrible judge just because of that. I'd like to hear what Justice Cobbs thinks as well.
Well, I think what you think. No, I think
not really hard on trial court judges.
No, you're not really hard on trial court judges, because we've been trial court judges, and so that you're ruling really pretty quickly. Trial court judges don't have the privilege, or they don't have the opportunity to sit back and to deliberate. Or to bounce it off of two other judges who are serving on the same case, looking at the same evidence and kind of like evaluating the same evidence and construing the law. So we're sensitive to that because trial judges have a mandate to decide cases and to move them along. I mean, in the criminal arena, we have the Speedy Trial Act. They've got to, bring that case, get that case to trial, get a decision, get a ruling, and that case has to move. Liberty interests are at stake. And so what trial judges are doing in what sometimes seems a nanosecond, we can take not as much time as we want, but certainly sufficient time to make certain that we rule correctly and that we understand what was going on in the trial court, what was before the court at the time, what was presented to the trial court in making the decision that the trial court made. Some errors that trial court judges make are harmless. They're harmless errors. Some errors that trial court judges make are reversible error. But I don't know that there is a perfect trial. If there is, somebody should point it out. I doubt very seriously that there is a perfect trial. In the trial court, it is like there is tremendous pressure to move the case, to move the cases off the docket. Litigants are looking for resolution to what are very real and serious disputes. And so I am sensitive to the fact that trial judges don't have the luxury sometimes of time that we sitting on the appellate court have. And we want to get it right as well. And not to suggest that we are not under time constraints, because we are. We have folks who are looking at how long a case has been sitting on our docket as well. So, for instance, the data about cases assigned to us and how long they've been on our docket is shared with the Illinois Supreme Court, who ultimately has supervisory and administrative authority over all courts. Now, we may not get a call from the Supreme Court to say, hey, you've got a case down here that's been sitting on your docket for 6, but that information is shared with the Illinois Supreme Court, and we have some responsibility to clear our dockets as effectively and efficiently as we expect the trial court judges to move.
And justices on the appellate court.
I'm sorry?
I was just adding that it's also shared with all of the justices.
Yes. Yes.
They all see it.
All right. Has there ever been a time where you have reviewed a case where you have said that this is just egregious? There are so many errors here.
Yes. And sometimes what bothers me the most is when I read the record and it's clear that the trial court judge is not allowing the lawyer to make a record, or that not allowing a litigant to make a record, that is constantly cutting them off, or telling. Maybe I've seen cases where somebody's on the stand and the judge just said, you don't have to answer that. Well, if there's no objection, they need to answer the lawyer's question. There needs to be an objection to it. If the judge shouldn't be objecting to the question unless it goes to a constitutional issue or something, and it's to protect someone's constitutional right. The judge may say, well, no, I'm not going to let them answer that question if it's something like that. Or if it needs to be totally irrelevant. If you're looking at, say, an eviction case and somebody asks a question like, something that's just off target, not related to the eviction case at all. How many traffic accidents have you been involved in? Well, that's not related to whether or not you should be evicted from your apartment.
Yeah.
So the judge may step in and say, hold on, counsel, I'm not going to allow you to go down this road. Things like that. And we both have seen cases where we believe that it should be reversed because there was egregious error, which is what Justice Cobbs talked about earlier, that sometimes that, and I would say even most of the time, the error is harmless error that we're looking at. But there are times where it's egregious.
Many times it's harmless, but there are times in my little short 9-point-something career as an appellate court justice where I have seen some instances where the conduct of the trial judge has just been unacceptable. And you'll read it. I mean, we try hard not to be bombastic or disrespectful of our colleagues in the judiciary, but we have a role and a responsibility as the reviewing court to point out error and to point out egregious error, or and when it's not harmless and indeed hurtful and sometimes unfair, we have that responsibility as well.
Let me just, for one point of clarification, she said that her little time on the appellate court. Let's understand that this is a person who ran the Supreme Court, who clerked for the first African-American Illinois State Supreme Court justice, who had later become the Chief Justice, who had selected for her to complete his term. So I just want to make sure that you all understand this is not a little body of work.
Thank you, Mark. I appreciate it.
Yeah. Thank you. All right. Just want to clarify.
Thank you. I appreciate
it. Yeah. So the reason I asked that, because, there are some judges out there, and hopefully there are only a few, that have abused that office where they preside, and have been participating in some very unethical ways. Are you able to see that when you're reviewing a case, and when you review a case that you see that as egregious case, are you able to discern that, hey, there's some ethical lines that may have been crossed here? That's a question.
Well, go ahead. Look, Mark said that's a question. Well, go ahead, Justice Walker.
Well, yeah, and we do see cases like that sometimes. And what we do sometimes do with those cases is that when we send them back, we'll send them back to be transferred to a different judge and not even have that same judge hear the case. We have the authority to do that. So where we believe that this judge, there's no way this person can get justice in front of this judge, most of the time the judge has made some sort of a comment, like, for example, well, I'll let you speak, but what you have to say is not going to have any impact on my decision. Well, in that case, I may as well just walking out the courtroom, right? If they already told me you're going to let me speak, but it's not going to matter to you. And we've seen judges say that. And when they do, that's a reason that if the case does go back, it should go back before a different judge that's willing to at least listen. Because we're not going to tell the judges how to rule when we send the case back. Because if we believe that it should be ruled a certain way and we have all the information we need, we'll do the ruling. But where we believe the trial court needs to get more information, because remember, Mark, the important thing to remember is at the appellate level, we don't receive new evidence. We're stuck with the trial court record. Right. And it's that record that guides us, binds us to for all practical purposes. And so if there's more needed, the trial court judge has to do that additional work and get that additional evidence in. And then when it comes back before us, because I've even had cases, and I'm sure Justice Cobbs has too, where we've sent it back and retained jurisdiction on the case. And that assures that the case comes back to that same panel. Then that same panel can review what the trial court did on remand, and then we can rule accordingly.
Justice Cobbs?
Well, I absolutely agree with everything my colleague has said. We can do anything that we think the trial court judge should have done. So we can reverse outright, or we can reverse and remand with directions. And sometimes when we reverse and remand, we may reverse and send it to a different judge. If we believe that a judge probably did not rule as fairly or as objectively as he or she might have, we are not the Judicial Inquiry Board. And so we have no ability or authority to discipline a sitting judge on any level. But what we do have the authority to do is to ensure that the litigant in every case receives the fairest, the most fair treatment that he or she can receive based on the facts in his or her case. And to the extent that we believe that there may be bias, although we can't remove a judge, we certainly have the authority to direct that the case, when it goes back, is heard by another judge. We can say to Judge Evans, assign this to a different judge in your division in order to better ensure that the ruling is fair and just and based only on an objective reading and review of the evidence presented.
Does that happen, more frequently, or is that a very rare time that recommendation happens?
It's rare. I think it's rare for me. I don't know about Justice Walker. He's different.
It's rare because, when you think about the number of cases that we go through in a year's time, we might have gone through total cases where we're on the panel and author well over 300, about 300 probably. And in that case, I say 200 to 300, and it may happen, I'd say no more than twice a year.
Yeah, rare.
The case back.
Remember, there are 24 appellate court justices in Cook County, and we are randomly assigned cases as the authoring justice. And generally, it's the authoring justice who will take the lead on the ultimate disposition in the case. So I may, as the authoring justice, say I'm remanding this to a different judge, but I really need and would like in those cases to have the concurrence of the two other justices serving with me. So we don't do it frequently because we don't take lightly the signal or the message that's being sent. And so we do it when it is absolutely necessary because every litigant is entitled to have a fair trial and have their disposition decided fairly, effectively, and efficiently.
Well, let's speaking of the litigants, because there are some people who cannot they cannot afford attorneys, and they have to represent themselves on pro se on cases because they just don't, they can't afford an attorney, and they believe strongly that they didn't get a fair shake in the trial court. But to many people, when you start talking about, well, you have a right to appeal, that sounds like, somebody has to go and climb Mount Everest to the average person. Just how complicated is it for someone to appeal to the appellate court? Is that a very complicated process? And do you really, most people need to have an attorney to appeal to the appellate court? Because the trial court is very different than the appellate court.
That's right. Well, I'll say a couple things, and I know Justice Walker is anxious to jump in. It's gotten easier. Not to say that it is easy. It has gotten easier, and it's gotten easier because there is now in existence a committee created by the Illinois Supreme Court called the Access to Justice Committee. And that committee has done a lot of really positive work in recognizing that a greater number of litigants are what we call pro se, representing themselves in a system that is more often than not foreign to them. They believe they have a wrong. They believe they have something that should be righted by the courts, but they don't have the wherewithal, financial or otherwise, to have that case presented before a judge. And so the Access to Justice Committee has spent a lot of time developing forms for the use of litigants who are not represented by attorneys, who seek to have their cases reviewed by the appellate court. And so it isn't still easy for them, because more often than not, there is still an attorney on the other side of the litigation who knows really well the rules of appellate procedure, how to craft an argument, how to support an argument in the law. But there has been good work done to assist litigants who we call pro se, self-represented litigants, who either cannot or will not take advantage of legal assistance to present a case on appeal. And we look at those. While we can't give either side any greater benefit than the other because you are unrepresented by an attorney, we still must treat you in the same way that we treat an attorney. We're not unaware that you are pro se or that you're proceeding without a lawyer. And I think that most of us make every effort to understand what the legal argument is, what the issue is, whether it has been preserved and is properly before us so that we can make a ruling on the merits, as opposed to dismissing it because it just does not present a clear and cogent argument for us to make a decision about.
And Mark, totally with this, Cobbs. The thing with it is that I just don't recommend it. I realize that, as you said, Mark, some people just don't have a choice. But there are some law firms now, they have these policies within their firms that the young associates can do pro bono work by representing people in court, not charging them anything. Pro bono means it's done for free, and they get credit for that. They even get bonuses for that at the end of the year at some of the firms. So I really would suggest that people go out and try to find someone at a large law firm or even a medium-sized law firm that's willing to represent them on the matter at no cost. And sometimes maybe it'll just be the actual cost of filing, which that can be waived. If an order comes before Justice Cobbs or I saying that this person, doesn't make a lot of money and they are asking if their fees be waived, we'll waive them. Of course, they have to have a affidavit attached stating, especially if they get any sort of public assistance, general assistance, or if they're on any kind of special program where they're getting food get brought to them for free. If they just show proof that they're on any of those programs, that qualifies them to get their fees waived in the appellate court and in the trial court. So I suggest that they do that, because I agree with Justice Cobbs. It's just not easy because as she stated, we hold them to the same standard. We're required to. They need to come in with some good work. And they got to explain the issues to us. They got to provide us with the record. And if they're the appellant is responsible for getting the record to us. And when we don't have the record, when we have no transcript, no record, we are under our rules. We're required to presume that the trial judge did everything correctly. And so it's unfortunate that life is this way, because everything is just so expensive and things have gotten worse since COVID. Just everything. I mean, just people can't afford to go to the grocery store anymore. And we recognize that as appellate court justices, and we do try to sort of read past the poor writing, if you will, and we'll just keep going and try to decipher what they're really saying as best we can. But again, we're talking about as best we can.
And sometimes when you have that situation where the appellant, the person who is appealing the lower court ruling, sometimes you can rely on the appellee's brief to discern what is the issue that is being raised here on appeal. To the extent that you can understand the issue is always, or the interest always is, deciding the case on the merits. We are not necessarily interested in finding that you forfeited your issue because it's not been properly set forth. We really have an interest in deciding the case on the merits. We're the court. We're your court. We work for the citizens. And so to the extent that we can decide the issue on the merits, and the citizens in Cook County can go away feeling like they were heard. There was a judge or judges who listened to my appeal or read my appeal and made a decision on the merits. That's the best. That's the best way, because people are really satisfied that, someone paid attention to what they were arguing. It's no different in the appellate court than it is in the trial court. You always want to be heard, even in the appellate court. So, there are resources. I would always say, look at bar associations when you're a pro se litigant. Bar associations can sometimes find lawyers who will represent you, even in an appellate case, free. So, but you don't know if you don't ask. But there are bar associations and law schools even that can point individuals who would otherwise be representing themselves. They can find resources or direct them to resources that can either provide them with lower cost representation or no cost representation. It's out there.
And you all provided some great information to a question that I didn't even ask. But I certainly was looking for you all to give that information. That's why, audience, that's why it is important and it matters who we support and who we elect to these offices. You have two of the most brilliant, two of the most compassionate, certainly capable people on the appellate court. That's why it's important for us to make sure that we vote and support and put the right people in the right place. And you certainly have done that by certainly re-electing Justice Carl Walker and Justice Cynthia Cobbs, both my friends and people who I greatly admire. Thank you both for coming on and giving us a great education on how the appellate court works.
Thank you, Mark. Thank you for having us. And we hope you'll have us back, because the more folks understand about how the judicial system works, the better it is for everybody all around. So we hope you'll have us back for part 2 and 3.
Well, you certainly, you know that I am going to actually hold you both to that, because I think it's important, and I certainly enjoy every time that I get the opportunity to speak with you all.
Yep. And Mark, I just ditto Justice Cobb's remarks and say thank you for having us on. We appreciate the opportunity to speak to the listening audience as well.
All right, fantastic. Thank you, Carl. Go back and enjoy your trip wherever you are in the world, and be safe. And we'll see you when you get back home. Justice Cobb, thank you both. All right, thank you all very much. Certainly appreciate it. Okay.
Bye-bye.
All right, take care. All right, bye-bye. All right, folks. So that's going to do it now. I want to remind you all that we are we got a few minutes left, but I just want to say to you that is why it's so important. And I love to bring people to you that you don't see every day, that we hear about, who are actually doing really good work, and why our systems are so important. Are so important. Not perfect, but we have checks and balances in this country. We have checks and balances in our county, our state, our cities where we are, and you can see how those checks and balances work and why they are important, right? So this is why it is essential that we certainly protect our democratic norms, and that we don't become so jaded that we will allow for ourselves to compromise because we're frustrated with some part of the process, or someone within the process, that it's, we take these attitudes that these sound bites that we hear on television, and we take them without doing any type of real research, and we sort of wrap this blanket sort of opinion, this blanket opinion over the entirety, right? The entirety of it. And it's not fair. And it's also not smart for us to do that. But, you know, I think we got a really good sense in this presentation, and I want to do more of that. Now, typically, you don't see me having a lot of people from the political spectrum on, and one of the reasons that I don't do that is because, number one, I think that it is important that we ask critical questions of people who are in public office, and that we have a very high demand of the people that we have in public office that represent us, and that we have a very high expectation of them. And what I do is to raise critical questions of all of them. And I have, like you, we have very, very high expectations for them, and hold them to an accountability level that they have to, or certainly we apply that kind of pressure that they perform. So I don't bring people on just so that they can pontificate. But there are times that certainly people that I bring on that I have great respect for, who are serving in our judiciary, and who may be serving in other publicly elected offices. And when people are doing great, I certainly want to recognize them. Certainly those, in my opinion, recognize those people, and to have you to be able to hear from them and to hear the work they do, especially in the judiciary, right? On the appellate court, we don't hear much about the appellate court other than there's an appeals court. When it comes time for an election, we don't know most of the people that we elect. I have had certainly a very grateful experience of being able to meet people like Justice Cobbs and Justice Walker and Judge Leonard Murray, who serves on the Cook County Circuit Court, to be able to work with them, to be able to dialogue with them, and to call on them, and to get information from them, and then to have them to come and present information to us. I'm very grateful to that. But these are people that I bring on that I have a tremendous amount of respect for, and I think that they serve the public and they serve our community well. So I will always support that. Unfortunately, there aren't more people that, in my opinion, that I have that sense of regard to. However, I certainly have that strong sense of accountability for them, and to making sure that we do all that we can for them to deliver. All right, in these last few minutes, I want to go through some more of the Biden-Harris administration and what their policies are doing, that they are delivering to Black communities. I definitely want to make sure we understand what they are doing, that they are delivering to Black communities. Now, if you all have people that think that it is a good idea for them to support, right? For them to support the other side or the most extreme ideas, or to support anybody who is associated with this today's Republican Party, whether it is local, whether it is state, or whether it is federal, anybody who identifies with the Republican Party, I am going to give you a reminder, and I'm going to keep giving you this reminder. Now, this is a man by the name of Paul Weyrich, who was with the um, um, Southern Baptist, the evangelical Christian conservatives. And Paul Weyrich, who was the architect of the Ronald Reagan campaign, this is exactly what the Republicans think about you participating in the electoral process. They don't think that everybody should participate. They don't think that every citizen of these United States has the right to vote. This was their ideology then, and it's their ideology now, which is why they are passing some of the most repressive voter suppression laws in southern states like Georgia, where they are trying to pass a law or have passed a law that says that married women must have an ID that matches their birth certificate if they want to vote. In Georgia, this is what their ideology is about voting.
Now, many of our Christians have what I call the goo-goo syndrome, good government. They want everybody to vote. I don't want everybody to vote. Elections are not won by a majority of people. They never have been from the beginning of our country, and they are not now. As a matter of fact, our leverage in the elections, quite candidly, goes up as the voting populace goes down.
Run that back again.
Now, many of our Christians have what I call the goo-goo syndrome, good government. They want everybody to vote. I don't want everybody to vote. Elections are not won by a majority of people. They never have been from the beginning of our country, and they are not now. As a matter of fact, our leverage in the elections, quite candidly, goes up as the voting populace goes down.
Voting in their mind that they could suppress the vote. That's really what that means. And that's what their effort has been since 1980, since the founder of the conservative movement, Paul Weyrich. That's what their ideology was then, and that's what their ideology is now. And if you think that that is a path or that is a side that benefits Black communities, poor people, working class people, you're mistaken or confused. All right, let me just take a few minutes. I want to just go through a few of these. These are policies that the Biden-Harris administration have passed and money that is flowing and will be flowing as long as that administration was there, and hopefully that we do the right thing in November in supporting the re-election of Joe Biden and Kamala Harris. If I have a little time, I'll get into this whole, what I think is absolutely foolish by the so-called elite from the Democratic Party, the party for which I am a part of, and I think that these elitist, and that's what they are, complete elitists, are completely out of line. It's showing just, either it is showing that maybe they don't want us to win. Maybe they don't like the idea of what this president is doing, that he's done so much better than what they did. That may be something that we need to consider, but we'll talk about that at another time. So now let me go back to the policies that are coming out of the Biden-Harris administration. And this is information that has come directly from the report from the United States Treasury Department, specifically that breaks down the policies that come as a result of laws being passed by Congress, that is proposed by the President of these United States of America. So this is the United States Treasury Department that releases the report on the historical, equitable, economic recovery throughout this administration and as it relates to the Black community. Now, we left off with the HUD and FHA insured loans that enabled 5,000 borrowers a year to qualify for insured FHA insured loan, which is a federal housing authority. That was put into place by Democrats, mind you, and put into place by Franklin Delano Roosevelt. Now, also, there's one thing that is being done by this administration that is going to impact millions of people's ability to borrow for a car or a house loan and get the best possible terms, because this president, Joe Biden, Kamala Harris, are moving to have medical debt removed from your credit report. That medical debt can no longer or will no longer be able to be reported to your credit reports or to be held against you on your credit report. That is going to be a big deal. There are millions of people whose credits are dinged, credit scores are low as a result of medical debt because they got sick, didn't have the insurance coverage, and can't afford to pay the debt. Well, the Biden-Harris administration is moving to make sure that all medical debt is moved or removed from your credit report and can no longer be held against you. That is going to be a big deal. Also, the Biden-Harris administration, all right, ensuring equitable educational opportunities for Black students to expand educational opportunities for the Black community in early childhood and beyond. The Biden-Harris administration has done the following: approved more than $136 billion in student loan debt cancellation for 3.7 million Americans through various actions, and launched a new student loan repayment plan. The savings on a valuable education, which is the SAVE plan, to help many students and families cut in half their total lifetime payments per dollar borrowed. Many, 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 disproportionately, Black students will benefit from this as a result of the language that the Vice President Kamala Harris put into the bill. How did that come about? Vice President Harris, Vice President Harris was wrote a bill when she was a senator and it was along race lines. This was along race lines, and Vice President Harris wrote this bill, and the bill was challenged in the Supreme Court, and of course, it was knocked down because you can't make policies based on race. But what Vice President Harris learned was that the way to do this was to include Pell Grants, which more than 70% of all Black students enrolled in college use to pay for their college education. So she included that language in this policy. So disproportionately, Black students are going to benefit through this $136 billion student loan debt cancellation. Big benefit to those Black students. Thank you, Vice President Kamala Harris. Thank you, Joe Biden and Kamala Harris, for including it in your bill through the Inflation Reduction Act. We also championed the largest increase to Pell Grants, here it is, in the last decade, a combined increase of $900 to the maximum award over the past 2 years, affecting the over 60% of Black undergraduates who rely on Pell Grants. Fixed the public service loan forgiveness program so all qualified borrowers get the debt relief to which they are entitled. More than 790,000 public servants have received more than $56 billion in loan forgiveness since October 2021. Prior to these fixes, only about 7,000 people had ever received forgiveness through the public service loan forgiveness program. Delivered historic investments, over $16.5 billion to support HBCUs. Let me say it again. $16.5 billion delivered by the Biden-Harris administration to support HBCUs. Reestablished the White House initiative on advancing educational equity, excellence, and economic opportunity for historically Black colleges and universities, and the White House initiative on advancing educational equity, excellence, and economic opportunity for Black Americans. Through the American Rescue Plan, secured $130 billion the largest investment in public education in history to help students get back to school, recover academically in the wake of the pandemic, COVID-19 pandemic, and address students' mental health. There's still a lot of work to do there. Secured a 30% increase in child care assistance funding last year. Black families comprised of 38% of families benefiting from federal child care assistance. Additionally, the president secured an additional $1 billion for Head Start, a program where more than 28% of the children and pregnant women who benefit identify as Black. Improving health outcomes for Black families. I'm going to put a pin in this right here, and then when I pick it up on one of the upcoming programs, we'll do this because I only have a few minutes left in this program. And I want to, first of all, I want to thank both of my guests, the Illinois State Appellate Court Justice Cynthia Cobbs and Justice Carl Walker, both for coming on and doing that roundtable. We're going to have part 2 of that, and hopefully one day we'll have more of the appellate courts on, because I want for us to get a real education on how these processes work, and to see how our judiciary is forming and how it works, and the importance of being engaged to shape our judicial norms as well as our political norms. We have to be engaged in the process. That's very important. Not to just be making a lot of noise, screaming, calling people names, that sort of thing. We need to be informed. We need to organize ourselves so that we have the facts together. We got to have the facts together. I didn't get a chance to put in the chat the link, but let me see. I may be able to do it before we conclude tonight's program. So let me see if I can do it right quick, and then I'll be able to put it up for us or for you in the chat, and then that way you can you'll be able to get it. Let's see if I can do that. I don't know if I have time to do it or not. I don't think so. Maybe we'll get it, but if not, there it is. Okay. I'm certainly going to try. I'm going to try to put it in there. Let's see if we can get it. Okay. I'm certainly going to try to do it. I'll put it in there. These last few minutes that we have. Just hang on. I might go over a little bit, but I got to get this in there. Let's see here. We'll get it. There we go. All right. Here we go. Where are we? There we go. All right. I'm going to put it in the chat there. You'll be able to get it. Hey, got it. All right. So it's in the chat. And so you'll be able to take it there. We're going to keep it up for a little bit longer. We're going to be going a little bit longer. We'll be going off the air in just a minute at intellectualradio.com. But what I do want to say, and for those of you who are listening at intellectual.com, thank you so much for listening to the program. Please make sure that you join us tomorrow night for our legal hour at 9 o'clock with Circuit Court Judge Leonard Murray from 9 o'clock to 10, taking all of your legal questions. Tomorrow night, we also have the men meeting, the Zoom meeting. I just put it up in the link for those to participate tomorrow night at 6 o'clock. We meet for just about an hour to talk about organizing this 200 Black men press conference on July the 19th at 9 o'clock at the Markham Courthouse. All right. So please share this broadcast on your social media with your other social media outlets. We certainly appreciate that. And certainly thank you all for participating in the program every Monday night, where we're bringing you hopefully important and helpful information. Thank you all for participating, and thank you all for tuning in to the broadcast. We'll see you next time right here every Monday night on intellectualradio.com for the People Show.